Thank you very much for joining us for our webinar today. The topic is fixed costs on the fast track. Just to quickly introduce ourselves, my name's Laura Fitzgibbon. I'm a junior barrister at Farrar's building. I've been in practice now for about 4 years. The majority of my practice is personal injury work, and within that, a fair percentage of it, particularly in court, is fast track work. So multiple times a week, I'm in court dealing with these types of issues that we're going to be covering today. And I'll just let Ros introduce herself as well.
Good afternoon, everyone. My name's Ros. I was called a year after Laura. So I started pupillage at Chambers a year after she'd set herself up. And we have fairly similar practices. So I'm not going to set that out again. But as she says, a similar ratio percentage of work split across different areas of Chambers, and as she said, these cost issues come up time and time again, so it's very useful for us all to have a bit of a refresher this afternoon, and I hope this is useful for you all. I'll hand back over to you now, Laura.
So as Ros said, we thought it would be helpful to have a run through of the fixed cost rules that apply to the majority of fast track cases, and certainly to all of the fast track cases that we've dealt with. The rules aren't the most straightforward, and they're not the most logical, and they are quite lengthy. And for that reason, I think in our experience, often there are points sometimes misunderstood, or sort of niche points left unexploited, which we hope will be quite helpful to go over all in one go. We hope that this talk will be helpful regardless of whether you act primarily for claimants or defendants. We're going to do our best to be quite balanced in the talk, and I think all of these points are worth knowing regardless of which side you approach the issues from. So in terms of the structure of the talk, we're going to go as a little bit of a canter through what we might call the normal fixed costs rules. So recoverable fixed costs and disbursements when the claim to which you're dealing with falls within part 45(3)(a). Also, then going over what the fixed fast track trial costs are to fast track cases which don't fall within part 45(3)(a). I'll then hand over to Ros, who's going to take us through some of the issues that you can encounter when you've got multiple defendants or multiple claimants in proceedings. Issues that arise when counterclaims are involved, a brief word on disposal hearings, Part 36 offers, and then a couple of points just on being restricted, or arguments about restriction to portal costs and applications, and then we'll come back to me for a final comment on quocs. Of course, quocs as a theme is going to run all the way through this talk, but there'll be a few final points just to wrap up. A point on questions. As we go through, if you see probably at the bottom of your screen, there is a Q&A function. If you have any questions as we go through, please do put those questions in the box. As I understand it, only myself and Ros can see those questions. So please do put those questions in as we go through, and we'll address them at the end of the talk if we've got time and if we're able to. If we don't answer your question either throughout the talk or at the end, then please do repeat them in an email to us. We'll put our email addresses on the last slide, and we'll do our best to get back to you. Just one thing as well, I thought it might be helpful to say is that it may be helpful if you have your own copy of the white book, so hard copy or electronic copy, or however it is that you normally access the rules, open in front of you, just so that you can follow along. Because of the length of some of the rules, they're not all included on the slide, so it might help to have some context to what we're talking about. So let's get started. I'm just going to hope that, yeah, I can see that. I think that the second slide has come up. Ros, would you give me a nod? Can you see the second slide? So what are the scope of the rules that we're talking about here? Well, part 45 itself is just entitled fixed costs and contains a number of parts within that part 45 that contain all the elements of fixed costs that don't just apply to fast track cases. Within that, we've got Part 45 3A, which applies to claims which no longer continue under the RTA or the Employers' Liability and Public Liability Protocol, or claims which the pre-action protocol for the resolution of package travel claims applied. We're going to focus mainly on RTA or ex-RTA and ELPL protocol claims, but the same rules would apply in many instances to claims to which the pre-action protocol for the resolution of package travel claims apply. The other part of Part 45 that we'll look at as well in a moment is fixed fast-track trial costs, which is Roman numeral Part 6, for cases that aren't portal cases, but we'll come to that in a moment. So focusing just on Part 45 3A, well, if you're a personal injury practitioner, you're going to be, these are going to be the fixed costs rules that you're most concerned with, and I expect are very familiar with. I think it's important to note, and just to bear in mind, it certainly helps me when I'm talking about or thinking about these types of costs, is that this is about what costs are recoverable into parties. They're not the costs that you actually incur, it's just what's recoverable into parties. So sometimes you're going to incur more and sometimes you're going to incur less costs than what the fixed costs are. More often more often you recover less, I expect. But I think that is quite a helpful sort of concept to just hold in mind when you're thinking about these cost rules. The scope of Part 45 3A is set out in Rule 4529 A and B, which is that broadly these rules will apply to claims which began under one of the applicable protocols, so the Road Traffic Act, the pre-action protocol for low-value RTA, low-value personal injury claims in RTA cases, and then also the ELPL protocol. That they start life under there, fall out for whatever reason, and they don't proceed under the stage 3 procedure, and for as long as they are not allocated to the multi-track, these rules will apply. That's quite a helpful rule to bear in mind if you've got any cases where it's a little bit tricky to decide whether or not these are the fixed cost rules that apply. So what are you entitled to under these fixed cost rules? Well, 4529B tells us that the only costs will be those in Rule 4529C, and then also disbursements. So when I say fixed costs, we're meaning fixed costs, or fixed costs in this context, we're meaning the fixed costs under Rule 4529C, and then because the term that everyone uses as a general rule is fixed costs and disbursements. So we're meaning fixed costs under 4529C, and then the disbursements under 4529I, which we'll come to in a moment. I should say this is, if I haven't already, that this is to do with, we're talking first about the fixed costs that are applicable to ex-RTA protocol claims. The fixed costs set out in Rule 4529C are helpfully contained in Table 6B, and it's a table that will be very familiar to you, I'm sure. It's the table that sets out the costs that the claimant will recover, and it simply depends at the time of which the claim is disposed of, and it's very straightforward in that respect. I'm not going to go through it all, it's on the screen, and I'm sure that you'll be familiar with it. It's important to remember that these are figures that you add VAT to if it's properly recoverable. And a point just to note, which is I think often perhaps misunderstood, is that for these fixed costs, they include the trial advocacy fee. So the characterisation, I think, is well put in the case of Aldridge and Chan, which we'll come to in a moment, or come back to in a moment. But it's well put at paragraph 52 of that judgment, which is that council's fees are a disbursement, but if the item of work to which they relate is deemed to be within the fixed costs regime at Table 6B, they will not be recoverable in addition to those fixed recoverable costs. So the trial advocacy fee is a disbursement. When you pay council, their fee is disbursement to the firm. But into parties and in terms of the recoverability of those costs, they form part of the fixed recoverable costs element, and they aren't separately recoverable as a disbursement. And I think that's quite an important point to bear in mind when you're trying to analyse some of the more slightly trickier situations in these types of cases. So moving on then, a couple of points about the fixed costs in 4529C, which I think are sometimes often overlooked, which is that in addition to those costs in the table, you are entitled in some instances to what we're going to call the area uplift. So set out on the screen there, but where the claimant lives or works in an area set out in Practice Direction 45, and those areas are set out in paragraph 2.6 of Practice Direction 45, which is reproduced on the bottom of the screen, on the bottom of the slide here. But where the claimant lives or works in one of those areas and instructs a legal representative who practices in that area, then essentially you can recover an additional 12.5% of costs. It's of note as well that this additional area uplift doesn't just apply to the fixed costs in 4529C, they apply to the mirror rule in the ELPL cost rules, and they also apply on applications and so on. All of the rules to which this area uplift applies are set out at the very beginning of paragraph 2.6 of Practice Direction 45 on the screen there. And of course, they're also contained in the rules when you look at them. Just a brief note so that we are doing justice to the ELPL claims or the fixed recoverable costs that apply to ELPL claims as well. The rules are essentially the same as under the RTA protocol, but the figures are just different. So Table 6C applies to employers' liability claims, and Table 6D on the screen there now applies to PL claims and claims under the resolution of package travel claims. I don't think there's very much more to say on those points. Moving on then to the disbursements, which are also recoverable under the fixed cost regime. So to recap, as I said, 4529B sets out that the only fixed costs recoverable are your fixed recoverable costs plus the disbursements. So to move on to the disbursements, that's under Rule 4529I. The list is reproduced on the screen there, and the most familiar ones or most common ones that come up are, of course, the cost of medical reports, court fees, witness expenses, and then the final one, which I'll come to in a moment, which is any other disbursement reasonably incurred due to a particular feature of the dispute. So dealing first with the witness expenses, it's important, or it's helpful to note, I think, that when you're dealing with witness or party expenses for loss of earnings or for loss of leave, for the purposes of attending the hearing or staying home to do that, staying away from home, sorry, to do that, then there's a cap on the on what the witness can recover from the other side, and those are set out on the screen there, and it's dependent on the value of the claim. As a practice point, in my experience, a witness is often taken at their word for what those loss of earnings are, or indeed they're sometimes just agreed between the parties. But I think properly some judges do sometimes refuse to award those without evidence of the same. And I would say that it's best as a general point of practice to ask your witness to bring along evidence of what their loss of earnings are, be that a letter from the employer or perhaps wage slips. I've had judges take evidence on oath from witnesses as well when I've really pushed them on it to say, oh, I really am going to lose my earnings today. But as I say, as a general point of practice, if they can bring along something to prove it, I think it's quite helpful as a bit of a belt and braces approach. Just going to move back a slide actually. So that is 4529I G for loss of earnings, but the witness expenses for under 4529IF, which is witness expenses for reasonably incurred in travelling to and from a hearing or in staying away from home for the purposes of attending the hearing. A point to note on those is that they're not capped. And I think, and have had in my experience, they can include the costs of needing to stay in a hotel, for example. And actually, I think they can also include reasonable childcare costs as well, if by having to travel to the hearing or from staying away from home, a witness has had to incur additional reasonable childcare costs. But I think that's probably a less common argument, and a witness would be well advised to bring along some evidence of what it is that it's going to cost them, just because it's not, the judges aren't going to be as familiar with awarding them. So again, a brief word on, continuing with a brief word on disbursements. When you've got a soft tissue injury claim started under the RTA protocol, then medical report costs and also the cost of medical records are going to be fixed. Again, I'm not going to go through them, they're on the screen there, but that's something that is often, I think, overlooked. They're fixed inter partes as to what you can recover. So a word now on the final disbursement rule, so 4529I2H, which is the sort of catch-all, any other disbursement reasonably incurred due to a particular feature of the dispute. We've got an authority on this, so what do we mean by the phrase due to a particular feature of the dispute? And that is, of course, the Court of Appeal decision in Aldred and Cham. That case concerned the recoverability, as I'm sure a number of you will be familiar with, of an infant, of counsel's fee for advising on quantum in an infant advice case that fell under Part 45(3)(a). Translator fees were also discussed by the judges in that case. And essentially what comes out of it is that fees for infant advice on quantum, translator fees and so on are not recoverable under this rule, as they are incurred due to a particular feature of the claimant and not of the dispute. So paragraph 35 sets that out for us, which is the fact that in a particular case, the claimant is a child or is someone who can't speak English or who requires an intermediary, is nothing whatsoever to do with the dispute itself. Age, linguistic ability and mental well-being are all characteristics of the claimant, regardless of the dispute. They're not generated by or linked in any way to the dispute itself, and therefore cannot be said to be a particular feature of that dispute. The court went on and said, gave some guidance at paragraph 36 as to what might be a particular feature of the dispute. So in an RTA claim, that would be how the accident happened, whether the defendant was to blame for the accident, the nature of the injuries, and so on. And so they went on to give some examples that particular circumstances of the accident may be sufficiently unusual to require an accident reconstruction expert, for example, or you might have such complex injuries that you require a number of different expert reports. And arising out of that, you might need an additional specific advice from counsel. So those are things that, depending on the facts, might be said to be a disbursement properly incurred as a particular feature of that dispute. But the current position is that it's wrong in law for the court to award a translator fee, or I should say a fee for translation of documents, or a fee for an interpreter to attend the hearing, or a sum for counsel's advice on quantum in an infant approval case falling under Part 45(3)(a). So I think in my view, counsel shouldn't be arguing that. It's just the position that's it would be wrong in law to do so. But the Supreme Court, have refused permission to appeal in this case in May last year. The reasoning given was that the case didn't raise a point of law of general public importance, but in the written reasons that the Supreme Court gave, they did say that they made a recommendation that the Civil Procedure Rules Committee have a look at this. And the recommendation that's been come up with by the Lacuna subcommittee of the Civil Procedure Rules Committee is that 4529I be amended to include provision that translator fees and fees for counsel's advice and quantum for approval matters are recoverable, and then also to change the catch-all provision, so 4529 I2H to be anything required by the rules rather than a disbursement incurred due to a particular feature of the dispute. Now, I've got this all from the Civil Procedure Rules Committee minutes, which are publicly available. So as far as I can see from those minutes, the position that we're now at is that this update has been provisionally drafted into the next update cycle to the practice directions, and that also, I think alongside that, MOJ policy is to consider it and revert to the Civil Procedure Rules Committee for further determination as necessary. So I think that the sum of all of that is simply watch this space. But as it stands, Alderton Cham is good law that applies to the current rules. So moving on from disbursements to defendants' costs generally under the fixed recoverable cost regime in Part 45(3)(a). Of course, in all of the cases to which these rules apply, Quox is going to come into play. And ordinarily, if the claimant simply doesn't succeed in their claim, and that the order is just that the claim is dismissed, then the most common order you're going to get is the claimant to pay the defendant's costs not to be assessed or enforced without further order of the court or subject to the Quox regime, or so on and so forth, because the defendant's never going to be able to enforce their costs, and so that's the most sort of common wording of the order that we end up with. But where Rule 45(29)(f) comes into play most often, I think, is probably where there's a split of liability. So the defendant is able to enforce their cost orders up to the level of damages that the claimant recovers under Quox without permission of the court. So 45(29)(f) is the rule. The rule is that defendants' costs are assessed on a standard basis, and they are capped at fixed costs, or the fixed costs operate as a cap. It's not the case that the defendants' costs are fixed costs, and I think that's quite a common misconception. So the proper thing to do would be to file a cost schedule if you are acting for a defendant, because the costs are going to be assessed, and then the fixed costs act as a cap. The rest of the rules in Rule 45(29)(f) apply on how to calculate that cap, and the area uplift applies too. Subrule 10 of 45(29)(f) makes it clear that where Quox is disapplied, the fixed costs cap, it doesn't apply. I'm not sure whether it necessarily needs to do that because it's pretty self-explanatory, but it does in any event. And I think just at this juncture, just a word on cost schedules, because I think that one of the tips that Ros and I would say in these cases is that it is often worth, as a defendant, to just put in a standard cost schedule for situations where this rule might come into play or any other. But a word on cost schedules for if you're acting on either side is that Practice Direction 44, paragraph 9.5 states that a statement of costs must be filed at court and copies served on any other party as soon as possible, but in any event for a fast-track trial, not less than 2 days before the trial, and for all other hearings, not less than 24 hours before the time fixed for the hearing. Now, there isn't any explicit sanction for not doing that, but it's always best to comply with practice directions. And what the court can do is, or will do, is to take the failure to comply with that rule into account when deciding what cost order to make, and also the amount of those costs if they're making a cost order. Right, so to move on from Part 45(3)(a) for now, and to address now other fast track cases which don't fall under those or under the remit of that rule. Now, I think most common are cases that concern claims for either credit hire or vehicle damage claims only, in terms of the cases that we deal with. But any other case that's on the fast track is going to have costs at large, so they're summarily assessed, all other things being equal. And it's save for that the fast track trial costs are fixed inter partes. Now, it's Part 45, Roman numeral 6, that applies in these instances. And the costs that are fixed are the advocate's trial fee, which are set out in table 9 of that rule, which they're pretty much the same, give or take a very small sum of money than the fixed costs that are applicable under Part 45(3)A. And also an additional £345 can be awarded for the attendance of a legal representative at trial if it's necessary for the advocate to be assisted. I'm yet to come across a case where that's been necessary, but it's there in the rules. I think at this point I'm going to hand over to Ros now to start talking about claims where you've got multiple claimants or defendants, sticking for the moment with these cases where costs are at large, but Part 45(6) applies just to the fixed fast track trial costs. So I'm going to put myself on mute now and hand over.
Thanks, Laura. So picking up from where Laura left off there, we're still in the territory of cases to which the fixed cost provisions of 45(3)A do not apply. And she gave a good example there of credit hire claims, for example, or vehicle repair claims. And as Laura said, an aspect of costs that remains fixed despite being outside of the regime is the advocate's fee. And she mentioned on that slide the table 9 that sets out what those advocate fees are. So what's the rule on advocate fees where there are multiple parties? Now, CPR 4540 is apart from 45(3)A, and it deals with this. And what the rules say, it's up on this slide here, where only one advocate is representing more than one party. So if you have one barrister for multiple claimants, for example, only one advocate's fee is recoverable. And when considering what that fee should be by reference to the value of the claim, as per table 9, as mentioned on Laura's previous slide, then the value of the claim will be the total amount of the judgment made in favour of all the claimants jointly represented by that one barrister. So where judgment, for example, is made in favour of, let's say, 3 claimants and judgment tots up to £7,500, say, the fee will be £690 and will only be recovered once. So that's important to bear in mind in a case where there are multiple parties in that situation, given that was an example for claimants. Where there are multiple advocates for multiple defendants, advocates' costs will be awarded to each party separately represented. So that's quite straightforward. And where there is only one defendant and multiple claimants, then only one award will be made for the defendant advocate's fee. So although you may have cross-examined multiple claimants, you'll only get one advocate's fee. And that advocate's fee will be the responsibility of the multiple claimants to pay, and they are jointly responsible for that fee. So turning then to the situation of multiple claimants and defendants in cases to which the fixed cost regime at 45(3)A does apply, and what we're looking at here is quite a different situation. So the case of Neary and Neary is the authority on this question, and His Honour Judge Pearce held that considering an application of fast track fixed costs under CPR 45(3)A to a single claim concerning multiple defendants, in that situation, he ruled that where there are multiple successful claimants within the same claim, their legal representative is entitled to the equivalent number of fixed costs and trial advocacy fees. And we've put in brackets there the top tip that Laura raised earlier about how crucial it is that the advocacy fee is considered in the context of fixed costs as opposed to a disbursement. And that's particularly important in this case, of course, because you're not going to get multiple disbursements. For example, you're not going to get multiple issue fees and multiple trial fees, court fees. You're going to, but you do effectively want the multiple advocacy fees. So it's good to think of the advocacy fee in the context of those fixed costs, as Laura mentioned earlier. So what's the rationale behind the decision in Neary and Neary? Well, in the portal, the word claim means a claim by a single claimant. So it's not possible to include more than one claimant's claim in a CNF, in a claim notification form. And so the word claim under 45.3a, under that regime, ought to be interpreted in the same way. The fixed costs, as we know, we've looked at the table earlier on, 6b, for example, that those fixed costs are prescribed by reference to the stage of proceedings of which the claim concludes. So that might be a settlement or judgment. And we've looked, as I said, at those tables to know when the different stages arise. And it must follow that each claimant's claim could conclude at a different stage of proceedings. And so therefore it's entirely logical that each claimant's claim should attract its own award of fixed costs. If, of course, each claimant were not entitled to a separate award, then there wouldn't be much of an incentive to solicitors to accept instructions from more than one potential claimant arising out of one single RTA. And that has the effect, a knock-on effect, of giving rise to situations where multiple issue fees are being incurred, multiple disbursements are being incurred. And that approach effectively is contrary to what the overriding objective sets out and what the general spirit of the CPR is. And it's also worth remembering, of course, that in the same way, and we're going to come to Part 36 in a minute, but in the same way that Part 36 operates as a separate code, 45.3a is also a self-contained code for fixed costs, making provision of awards for these types of portal cases. And those codes, 36 and 45.3a, sorry, ought to really take precedence over any other apparent inconsistent part of the CPR. So we've looked at on the previous slide 45.40 in relation to claims where the costs are at large. And what we have is we have a different regime for multiple claimants and defendants under the 45.3a provisions. So that's worth bearing in mind. You need to remember that there's a distinction between the two. So moving on now to look at counterclaims on the next slide. It's worth noting from the outset that the rule on counterclaims sits within the regime at 45.3a, but the rules, and we'll come to them in just a minute, apply to cases that don't normally have the 45.3a regime attached to them. And I'll come to this in just a minute. We'll have a look at that. And another important point to note from the outset is that a counterclaim is a claim. So whether a claim is considered as a claim or a counterclaim will depend on whether it's brought first or second. And that's important when looking at costs. So if we have a look at CPR 4529G on the screen there, if in any case to which this section applies, the defendant brings a counterclaim which includes a claim for personal injuries to which the RTA protocol applies, the counterclaim succeeds, and the court makes an order for the costs of the counterclaim, then the fixed cost rules will apply. So like any other PI claim brought by a claimant, on the counterclaim, the defendant will be entitled to, when it's successful, to the fixed cost. So for example, if the counterclaim successfully disposed of at trial, then it'll be the regular 2,655 plus 20% of damages and the trial advocacy fee and all the other disbursements that apply. Of course, that's in relation to a PI counterclaim. Looking now at subsection 2, this is a situation where there is no PI on the counterclaim, and it's quite a different rule that's provided for here. So where a successful counterclaim does not include a claim for personal injuries, the order for costs of the counterclaim shall be for a sum equivalent to 1/2 of the applicable type A and type B costs in table 6. Now, I'm sure you're very familiar with this already, but that unfortunately amounts to a rather disappointing sum of £250 plus VAT. And of course, as it goes on, it entitles you to disbursements too. But you can probably see the huge disparity between a PI counterclaim and a non-PI counterclaim and the effect this has on costs. And I'm sure you've come across this situation before. It does feel a little bit illogical and certainly quite unfair, especially for defendants, because what costs you get effectively is determined by where you come in the race as to bringing your claim first or second. To give you an example of how this unfairness might arise in a situation, I'm sure Laura and I have both come across this. If the claimant brings a claim with no PI, so let's say it's a vehicle damage sort of claim, and it's therefore costs at large, if the value of that claim is less than £10,000, then ordinarily that claim would be allocated to the small claims track. And the effect of that is that the claimant would be limited to the small claim fixed costs, which would include a issue fee, a trial fee, and solicitor's costs of not more than about £100. But if a counterclaim is brought, also not for PI, and that claim is obviously brought second, so after the claim, and if the value of that counterclaim takes the proceedings into the fast track, so it exceeds £10,000, for example, then what happens is the claim and the counterclaim both appear in the fast track. The claimant's costs on the fast track become costs at large, which is a huge jump from the fixed costs on the small claims track. And the defendant's counterclaim cost is still restricted to £250 plus VAT. That can feel very, very unjust and unfair to the defendant's solicitors. But unfortunately, we're stuck with the wording of the CPR. There's very little room for interpretation. It's not one of those grey areas. The point is often conceded by defendant barristers in these situations. And I've only come across a handful of situations where opposing counsel for the defendant has taken issue with the unfairness of this. And the judge has simply reread the rules to himself, and applied them as they are. There's really very little scope for doing otherwise. So you don't really get very far, even if you do try and raise an argument about the injustice of it. So moving on to the next slide, here's a very just quick summary slide of what we were just talking about. PI claim and non-PI counterclaim, we'll go through them again, but those are the effects. Non-PI claim and PI counterclaim, those are the effects there. So that is a useful summary slide. But what happens when both the claim and the counterclaim are for PI? What happens in relation to costs and Quox protection? So let's have a look at the next slide. This debate has thankfully been put to bed since the case of Sutcliffe, Jim Sutcliffe, and Aftab Ali and Aviva Insurance, as you see it up there. Now, the argument is as to whether both the claimant and the counterclaimant are Quox protected. This argument turns largely on the construction of the word proceedings, and that word, of course, appears in the Quox rules at 44.13.1. And the question here is whether we're to take a wide meaning of the word proceedings to encompass both the claim and counterclaim, or a narrow construction. And the narrow construction is what's won for now. That's the position in Sutcliffe. But just to give you very briefly some quick context, before the case of Sutcliffe, there were two decisions from the circuit bench, Ketchen and McEwen and Waring and MacDonald, that provided diametrically opposed conclusions, which was most unhelpful for us all at court. In the case of Ketchen and McEwen, His Honour Judge Friedman concluded that a counterclaiming defendant should have the protection of Quox in relation to the claimant's cost of the claim, meaning that where this claimant succeeded on the claim to which there is a counterclaim, no cost could be recovered by the claimant because the defendant is Quox protected. So that took the wide interpretation and meaning of proceedings. In the case of Waring and MacDonald, on the other hand, His Honour Judge then concluded that an unsuccessful counterclaiming defendant only had the benefit of Quox protection in respect of his own claim for damage for personal injury. He did not benefit from Quox protection in relation to his defence of the claimant's claim for personal injury. So that takes the more narrow approach, looking at the claim and the counterclaim separately. And this was widely viewed as the better decision. And Sutcliffe has gone on to support that. Very briefly, just to quote what was decided in that case: "In my judgment, the defendant is not to be viewed as an unsuccessful claimant in the proceedings as a whole, but rather as the unsuccessful defendant in the claim, albeit that he was also the unsuccessful claimant in his own personal injury claim." So that's where we stand in relation to recovering costs with two Quox protected claimants and counterclaimants. So we move on to disposals. Now, a disposal hearing, what is it and what award of costs should it attract? Well, a disposal will arise from a case that started in the protocol. It then falls out of the protocol either because liability is denied or the defendant didn't respond in time. Those are just a couple of examples. Default judgment is entered, and then the matter is listed for a disposal hearing, which is effectively a contested quantum hearing. As we see from that first bullet point, if started under the RTA protocol, it is still within fixed costs because of Rule 4529B. And what does 4529B says? It says, subject to Rules 4529F, G, H, and J, and for as long as the case is not allocated to the multi-track, if in a claim started under the protocol, the CNF is submitted on or after the 31st of July 2013, the only costs allowed are A, the fixed costs in 4529C, and B, disbursements. So the question then is, what level of fixed costs within Rule 4529C should apply at the disposal hearing? And this question has usefully been answered, and the issue's been put to bed again in the case of Bird and Acorn Group. It's a 2016 case, it's listed on the slide there, in which it was decided that listing for a disposal hearing pursuant to paragraph 12.21a of the practice direction to CPR part 26 is listing for trial for the purpose of determining the applicable level of fixed costs. So in Bird it was held, and I quote, "A reference to trial is a reference to the final contested hearing." So that has very much clarified the situation for us. In fact, I'm just going to ask Laura to chip in here, because I think she's had some practical experience of this. Let me hand over to her very briefly.
Yeah, the only thing I was going to say is to add to what Ros has got to say on this is that I've had 2 situations where I've been required to do written submissions on this point. I think it arises out of, it's not a universally known point known by judges, because it is a bit niche. I think in my experience, it was a combination of disposal hearings being listed for a very short period of time, being completely unopposed in both cases, and so the judges wanting to be particularly careful with what they were doing, and the particular judge that I was in front of not being a PI specialist judge, and I think in one of them quite a new judge, so just simply hadn't come across this issue before. On both occasions, we did written submissions, and of course, the case of Bird and Acorn Group persuaded them of that's the law. But just a tip in hindsight is that the necessity for that might have been prevented if perhaps on the cost schedule, well, on the fixed cost schedule that was filed and served, might had a reference to these are fixed costs to the staging post of a trial that we are going to be claiming following the decision in Bird and Acorn, with a reference to the case, for example, because that would have given the judge a heads up in advance that was the applicable position, and also that the other side had been put on notice that was the position. So I think just as a practice point, that certainly wouldn't hurt.
Thanks, Laura. I'm going to move on now to look at Part 36. So this is a bit of a whistle-stop tour of Part 36. It's just a bit of a refresher set of slides for you. Of course, the starting point, and I referred to this earlier, Part 36 is a self-contained procedural code, and it does very much have that effect of trumping the regular fixed cost provisions, and we'll see how that operates in just a minute. So we're going to look at 5 scenarios briefly. The claimant obtaining judgment more advantageous than their Part 36 offer, so the claimant beating their own offer. Number 2, where the claimant fails to obtain judgment more advantageous than the defendant's offer. Number 3, acceptance of Part 36 offers in time. Number 4, late acceptance of Part 36 offers. And 5, just a quick note on liability only offers. So let's look at the first scenario here. The claimant obtains judgment more advantageous than their Part 36 offer. Now, the rules don't provide explicitly for what one might do in this scenario, but thankfully we have the case of Broadhurst Tan to help us along the way. So by way of context, just to explain what the issue is, Rule 4529B provides that for claims started under the RTA protocol with a CNF submitted on or after the 31st of July 2013, the only costs allowed are the fixed costs in Rule 4529C. Now we've looked at this at length, and it's going to come up time and time again in this Part 36 provision. So there is an apparent tension between what's set out there in the regime at 45.3a. The tension arises in relation to Part 36.17.4, which, as we know, allows for more than just the fixed costs. So this issue was aired in the Court of Appeal, in this case of Broadhurst Tan, and they ruled that the approach to assessing costs for claimants who have made successful Part 36 offers where that 45(3)(a) applies, in these circumstances, they admit that although there may be some difficulties in assessing costs which are to be partly fixed and partly assessed, the approach where the claimant beats his own Part 36 offer will be A, to award the claimant his fixed costs to the last staging post provided by Rule 4529C in Table 6B, and to thereafter assess the claimant's costs on the indemnity basis from the date that the offer became effective. So this case has usefully set out what the consequences are. So the relationship effectively between the 45(3)(a) regime and the fixed costs under that and Part 36(17)(4), which, as we know, gives an extra set of costs to the claimant. So just looking very, very briefly as a quick reminder of 36(17)(4), the claimant will be entitled to interest on the whole part of any sum of money, excluding interest, awarded at a rate not exceeding 10%, costs on the indemnity basis from the date on which the relevant period expired, interest on those costs at a rate not exceeding 10% above base rate, and an additional amount which shall not exceed £75,000, which is calculated by applying the prescribed percentage of 10%. So those are the effects, and effectively what we've been told in this case is that both sets of cost provisions apply here. You get the fixed costs and you get the Part 36 benefits. Looking at the next slide, this is the second scenario where the claimant fails to obtain judgment more advantageous than the defendant's Part 36 offer. And we've put a little paragraph there in brackets, and this is the trumping effect of Part 36. So where, in a case to which this section applies, upon judgment being entered, the claimant fails to obtain a judgment more advantageous than the defendant's Part 36 offer, Rule 3621 will apply instead of this rule. And we're going to look at Rule 3621 in just a moment. But just so you know, Rule 3621 works in conjunction with 3617(3), which we've listed on that slide there. And 17(3) says the defendant is entitled to costs from the date on which the relevant period expired and interest on those costs. So we need to know what those costs are. And looking at the next slide, we have the answer in CPR 3621, which sets out what those costs are to be. So where an order for costs is made pursuant to Rule 3617(3), which we've just looked at, the claimant will be entitled to its fixed costs for the stage applicable at the date on which the relevant period expired, and the claimant will be liable for the defendant's costs from the date on which the relevant period expired to the date of judgment. Now, I'm just going to pause there a second, because I know Laura and I have had a number of chats over the years about Part 36, and one of the easiest ways we find that explaining Part 36 consequences is by having a sort of timeline in one's head with 4 crucial points along that timeline. So you'll have a straight line, and you'll have the beginning points of the timeline, which is the start of the claim. You'll have a second point in the timeline when the offer is made, a third point on your timeline where the offer expires, and the last point on your timeline, which will be settlement of judgment. And that's quite an easy way of setting out which costs apply to whom at what stage. So just recapping on 3621 there, in this situation where the claimant fails to obtain judgment more advantageous than defendant's Part 36 offer, the claimant will be entitled to the fixed costs applicable at the date on which the relevant period expired. So that's going to cover the first 3 points on our timeline, and then the defendant will get its costs from the date on which the relevant period expired to the date of judgment. So that last stage on the timeline relates to the defendant. But we still haven't answered the question, what are the defendant's costs? So we go on to look at subsection 9, where the court makes an order for costs in favour of the defendant. The court must have regard to, and the amount of costs ordered shall not exceed, and here comes the calculation, the fixed costs in table 6B, 6C or 6D, applicable at the date of judgment, less the fixed cost to which the claimant is entitled under paragraph 2 or 3. So we know that the claimant, looking at 2A above there, is entitled to costs on those first three points on our timeline. And to give a complete sort of arbitrary example, but it might help sort it out in everyone's head here. Let's say in this case that the offer was made post-issue but before trial. Then we've looked at the tables with Laura as to what the applicable fixed cost would be. It's about £1,160 from the top of my head, and of course 20% of damages. That is effectively what the claimant is entitled to. And then we're looking at what the defendant's fixed cost at judgment would be, and that would be £2,655 plus 20% of damages. And what you're doing effectively is you're taking one figure away from the other, and it's the remaining figure, which is what the defendant is effectively entitled to. It's a bit of a messy calculation, but it's set out in CPR 3621 quite clearly there. And as long as you've got your head around the timeline, then it shouldn't cause too much confusion. So moving on to the next screen slide, acceptance of Part 36 offers in time. Well, this is very straightforward. Again, we've got the trumping effect here of Part 36. We're looking now at Rule 3620. Where a Part 36 offer is accepted within the relevant period, the claimant is entitled to the fixed costs in Table 6B, 6C, 6D, for the stage applicable at the date on which notice of acceptance was served on the offeror. So that's very straightforward. And there's an extra note here. So in subsection 3 of Rule 3620, where a defendant's Part 36 offer relates to only part of the claim, and at the time of serving notice of acceptance within the relevant period, the claimant abandons the balance of the claim, the claimant will be entitled to the fixed cost in paragraph 2 as above. So there's no sort of deduction or alteration to the claimant's fixed cost based on the settlement being only for part of the claim. So let's look now at acceptance of the defendant's Part 36 offer after the expiry of the relevant period. Again, this is dealt with at Rule 3620. Where the defendant's Part 36 offer is accepted after the relevant period, the claimant will be entitled to the fixed costs for the stage applicable at the date on which the relevant period expired, and the claimant will be liable for the defendant's costs for the period from the date of expiry of the relevant period to the date of acceptance. That's very straightforward there. And moving on to the next one, where again we're looking at what those costs of the defendant would actually be. Where the court makes an order for costs in favour of the defendant, the court must have regard to, and the amount of costs ordered must not exceed. We've got the fixed costs in Table 6B, 6C or 6D applicable at the date of acceptance, less the fixed cost to which the claimant is entitled to under paragraph 4 or 5. So also disbursements, of course, listed at subsection 13 there. But we've got a similar calculation to what I just gave an example of on the previous slides. Let's move on to the next one. What about a situation, a scenario where there is acceptance of a claimant's Part 36 offer after the expiry of the relevant period? Now, this isn't provided for explicitly in the rules, but thankfully we have the case of Hislop and Purday, 2018 case, which deals with this, and it's incredibly straightforward. CPR 3620 does not have the effect of disapplying fixed costs where there's been late acceptance of the claimant's offer. So the normal fixed costs will apply unless there are some exceptional circumstances under 4529J. So again, that's fairly straightforward there too. So moving on now to liability only offers. Now, I'm sure Laura's come across this in her experience as well. I had this just the other week. We've all seen it. We've all seen offers which are made on liability terms. It might be a percentage or a split. And there's no other mention of agreement between the parties on issues such as causation or quantum. What effect does that offer have? Well, in my experience, that liability only offer is unlikely to bite. It's unlikely to have any effects because it can't really be viewed as a proper settlement offer. But as I say at the bottom of that slide there, much of this debate will turn on what the wording and the terms of the offer really are. And there was a recent case where, just very, very briefly to go through it, was a personal injury claim. There were two heads of loss. There was a neck injury and a back injury. Breach was admitted by the defendant. Causation was denied. the claimant made two very similar offers, but they weren't identical. They were, of course, Part 36 offers, and both offers were to accept 90% of the claim for damages and interest to be assessed on the basis that liability was admitted. Judgment was entered and damages were awarded. And the issue that came before the Court of Appeal was, firstly, were the offers genuine attempts to settle? And secondly, did the claimant better the offers, despite the fact that nothing was actually awarded for one of the losses, which was the back injury, and 100% was awarded for the neck injury. So Lady Justice Asplin gave judgment on this, and just to quote part of the judgment on this, she said, had Mr. Adam, the defendant, accepted either of the Part 36 offers, it would have meant that he had admitted liability for both the neck and the back injuries, and he would not have been able to argue subsequently that he had not caused the back injury at all. It follows that as he was only found liable in relation to the neck injury, Mr. Adam, the defendant, had bettered both of the claimant's Part 36 offers. No Part 36 consequences to the claimant were therefore triggered. And there is a final paragraph in this judgment that gives a bit of a word of warning to anyone thinking of making a Part 36 liability offer, and says that the precise wording of the pleading and the particular terms of the Part 36 offer are really, really important when making these sorts of offers. So that's something definitely to bear in mind. I'm going to move on to the next slide. I'm conscious of the time. Restricting costs to portal costs. Now this is set out at Rule 4524, and there are a number of situations that might arise where an argument is raised as to the claimant's conduct and why it is that the claim has fallen out of the portal, for example, and why it is that portal costs ought to apply here as opposed to the regular fixed costs. So we've given a number of situations there that could arise. So where the claimant provided insufficient information in the CNF so that the defendant could not proceed with the process, where the claimant has unreasonably discontinued the portal process, where the claimant has unreasonably valued the claim at more than £25,000, where the claimant acted unreasonably in causing the process and the protocol to be discontinued in any other way, where the claimant did not comply with the protocol at all, where they should have. So these are points that are worth bearing in mind. There's no authority, as far as I'm aware, on this, but it's probably worth, if there is non-compliance and you think costs ought to be restricted to the portal costs, then plead it early, because it may help induce settlement, and equally claimants bear this in mind. Moving on then briefly to applications, there is a whole section on interim applications at Rule 4529H, where the court makes an order for cost of an interim application to be paid by one party in a case to which this section applies. The order shall be for a sum equivalent to 1/2 of the applicable Type A and Type B costs in Table 6 or 6A. So we're back to the rather familiar and disappointing £250 plus VAT. Of course, you get your area uplift if it applies, and Laura mentioned that earlier, and you get your VAT, of course, but you also get your disbursements relating to the application. It may be the application fee. So much will depend on the type of application that's being put before the court. So just to run a couple of examples, applications for relief from sanction. Where the relief is granted, the successful party who has been able to obtain relief will very, very rarely be awarded costs for their failure to have done something. More often than not, it's the other party that's awarded the £250 plus VAT, because they may in some way have been affected by the defaulting party in some way or another. And of course, they may have had reason to oppose the application and incurred costs in doing so. What about strikeout applications? Well, if you're successful, you might get a cost order that is enforceable. So a schedule, of course, would be needed in these situations, and Laura's already stressed that point. You'll want to have your schedule before the court if there's a strikeout application, and if you don't do so, then you might just be limited to those fixed costs of £250 plus VAT. Pre-action disclosure applications. There is an authority in the White Book on this, Sharp and Leeds City Council. I'm not going to go into any detail on it, but it was agreed by the Lord Justices of that case that the fixed cost regime plainly applies to the cost of a pre-action disclosure application, and it's entirely in keeping with the overriding objective to keep costs down in restricting the costs in that way. However, in that case, it also set out that there can be exceptional circumstances under 4529J that would have to be shown, of course, in order to bring the case out of the fixed cost, the application out of the fixed cost regime, and for those costs to be at large. That's a very quick run through of applications and a number of other points. I'm going to hand back over to Laura now, who's going to take you through a couple of reminders on quoks.
I'm also very conscious of the time, so I'm going to just somewhat whiz through this. Of course, quoks is a theme, or has been a theme all the way through these rules. But I think it's worth just remembering and sometimes revisiting the wording of the rule. I'm not going to read it out, but the wording is on the screen now. I think it's quite helpful to bear in mind that quoks doesn't mean that the defendant will never recover their costs. It just means that essentially the claimant won't, unless the exceptions apply, lose money through trying to bring a personal injury claim to which quoks applies. And I think that's worth bearing in mind whether you're representing a claimant or a defendant. Just a final slide, I think, relevant to this talk is ways that a defendant might recover their costs as between either from the claimant or inter partes. Now, of course, there's the one that we're all very familiar with, which is fundamental dishonesty. The costs then become recoverable under the exceptions in the quoks regime as against the claimant. Similarly, strikeouts of the claim for reasons under Rule 4415, which again is exceptions to the quoks regime, which includes strikeout for abuse of process, for example. And then the defendant, and this is something that I think again is often missed, is costs can be recoverable from another defendant if there is more than one defendant in a claim, by way of a Sanderson or a bullock order. Quite often that comes in sort of multi-car pile-up cases, that those sorts of arguments might come into play. And also it's worth bearing in mind the decision of Cartwright, which is that if there is more than one defendant and one is successful and one is unsuccessful, then the successful defendant can enforce their costs order against the claimant up to the level of damages recovered from the unsuccessful defendant under a court order. I think it's just worth flagging those points. And really, we cannot do justice to this point. And indeed, that's illustrated by the fact that Joel McMillan did a webinar just on essentially just on this point, I think last month, but certainly it's on the Farrar's Building YouTube channel, and it's there for you to have a good, I think, nearly an hour just on this topic alone. But worth mentioning at the end of this talk in any event. So that brings us to the end of what we were going to go through. I'm very conscious of the time, and I think that probably we don't have time to address any substantive queries, unfortunately, but I'm just going to check whether there's anything that we can very briefly address. So if you just bear with us a moment, we'll just have a quick flick through and see whether there's anything that we can very briefly address. So a question with regards to Ros, I'll just run through a couple if that's all right. A question with regards to Aldred and Cham. It is definitely still acceptable. So the question is, in the interim, while the CPR has not been updated, is it still acceptable for defendants to argue infinite advice that an infinite advice on counsel from counsel and or translator's fees should not be recovered? Yes, that's exactly the point. I think that's the law. They're not recoverable inter partes in terms of the law. So that's that I can answer very quickly. I think we have answered the, right, let me just double check. The Bird case, with regards to disposal hearings, there's a question here about Bird and Acorn and as it applying to ELPL cases as well as RTA cases. I mean, it's actually an ELPL case, and there's a part of the paragraph in the judgment where the judge says they're the same rules that applies to ELPL and RTA. Now I think I can see there's a number of other questions there that we I'm not sure that I am able to answer substantively at this point, but I can see there's a question about getting a copy of the slides. I'm actually not, I should have checked this before, but it may be very much that they are being emailed out to everyone who registered for this webinar. If they are not, then I'm just going to make, oh, I can see that Kelly, who is hosting this webinar, is currently typing an answer to that question. I think the answer is going to be they're going to be emailed out to everyone, but certainly this Ros is nodding.
I think the recording of the webinar with the accompanying slides out to everyone.
Yeah, and then the recording of this will be put on YouTube as well, I think. Ros, is there anything there that you can answer quickly?
Not quick. No, sorry. I've just been trying to read through them, but I think there are a few of those points that we can address in an email with a paragraph, if that helps. Okay,
so I think if there's a question that you've asked that we haven't had a chance to answer, then please do send us an email. Our email addresses are on the slides now. And I think all that remains to say is thank you very much for listening. And as I say, if you could drop an email if you do have any further questions or we haven't answered your question, and we'll get back to you as soon as we can. But thank you for that. Have a nice evening.
Just to echo what Laura said there, have a lovely evening. Thanks again. And do by all means check out Farrar's other webinars that are online as well. I'm sure you'll find some useful tips and pointers on all sorts of other subject areas. Okay, thanks very much. Have a lovely evening. Bye-bye.